Good morning. This is your Kelso Report for Wednesday, November 23rd, and I'm your host, Clark Kelso. Our featured case today, Friends of Shingle Springs Interchange versus County of El Dorado, falls into the category of Don't Let This Happen to You. To remain in good standing as a corporation, the corporation must pay its taxes and annually file updated statements of information pursuant to Section 1502 of the Corporations Code. If it fails to observe these basic requirements, the Franchise Tax Board and/or the Secretary of State, after several warnings and notices, can suspend the corporation's powers until the corporation brings itself back into compliance. So, how bad can that be? You just pay the back taxes and file the right documents and you're back in business, right? Well, the answer is almost, but not quite. According to Section 2205D, or Section 5008.6, once the taxes have been paid and/or corporate documents have been filed, the corporation may be relieved from suspension. But during the period of suspension, the courts have uniformly held that the corporation lacks standing to sue, and statutes of limitations are not tolled. Once the delinquent corporation has satisfied its obligations, its powers are restored, thus reviving its capacity to sue and defend. However, the revival of corporate powers is without prejudice to any defense which has accrued by reason of the original suspension. As a result of these principles, a suit filed by a corporation that is suspended is ineffective because of the suspension, and any otherwise applicable statute of limitations continues to run. And the kicker, of course, is that if the statute of limitations runs out prior to revival of the corporation's powers, the corporation's actions will be time-barred, even if the complaint would otherwise have been timely. Well, in yesterday's case, the plaintiff, a non-profit formed to oppose the development of a Circle K convenience store and gas station adjacent to Highway 50 at the Shingle Springs interchange near Placerville. The nonprofit was not very good about paying its taxes or making its annual filings, and it received appropriate notices leading to the suspension of its corporate powers. Meanwhile, the CEQA process with respect to the development project kept moving forward. The county ultimately certified the CEQA filing and approved the project. The plaintiff filed suit under CEQA to challenge the certification and approval, but it did not successfully revive its corporate powers until after the applicable statutes of limitations had run. The Superior Court sustained a demur based on the plaintiff's suspension and lack of power to sue and dismissed the case. The Third District affirmed the dismissal. Although the plaintiff urged that the doctrine of substantial compliance should apply, the Third District held that in the particular context of CEQA claims, where there is a deliberately short limitations period of 30 or 90 days, it would not apply the substantial compliance doctrine. According to the court, developers and public officials charged with making these critically important land use decisions should not have to wait while possible challengers resolve their corporate formality problems. So the bottom line here is that the nonprofit, which had been created several years before for the specific purpose of challenging this one development project, managed to blow its chance in court because of a rather careless attitude about filing its annual statement of information and keeping current in the payment of taxes. As I said at the beginning, don't let this happen to you. Well, our first one-liner today in the area of environmental law and endangered species, a very important case from the Ninth Circuit, involving the grizzly bear. In Greater Yellowstone Coalition versus Wyoming, the Ninth Circuit vacated the decision by the U.S. Fish and Wildlife Service to delist the Yellowstone grizzly bear population from the Endangered Species Act, because of progress made in restoring the number of grizzly bears pursuant to a grizzly bear recovery plan adopted by the service in 1982 and the adoption in 2007 of a final conservation strategy for the grizzly bear. The court approved the service's conclusion that there were adequate existing regulatory mechanisms other than the Endangered Species Act for protecting the population. However, the panel concluded that the rule delisting the grizzly did not articulate a rational connection between the data before it, which showed a decline in white bark pine trees and seeds, which are a major food source for the bears, and its conclusion that white bark pine declines were not likely to threaten the Yellowstone grizzly bear. Given the absence of this rational connection between the data and the service's conclusion, the Ninth Circuit affirmed the district court's order vacating the rule delisting the grizzly bear. Now, reading the opinion, I have to say it does appear the panel gets pretty deeply into the science and into scientific judgment calls, so I would not be surprised to see an en-banc or Supreme Court review. This is not a case where the service ignored the data. This appears to be a case where the court simply disagrees with the service's analysis of the implications of the data. And that, of course, gets very close to having the court substitute its judgment for that of the agency. And that's, of course, a no-no when it comes to judicial review of administrative agency decision-making. Our next case is a state habeas corpus matter. In In re Hernandez, the 6th District reversed the Superior Court's order, which granted a petition for a writ of habeas corpus and ordered the Board of Parole Hearings to conduct a new hearing for the petitioner. The Superior Court found that the Board used the wrong legal standard in denying parole and failed to articulate a nexus between the life crime and its conclusion that the petitioner was unsuitable for parole. In essence, the Superior Court concluded that the Board denied parole essentially automatically because of the serious nature of the crime. The 6th District reviewed the record and held that, no, the Board had properly articulated a nexus between the facts supporting a denial of parole and the Board's ultimate determination that the petitioner was unsuitable for parole. The petitioner also claimed that the 2008 amendments to Marcy's Law violated the ex post facto clause, an argument this court rejected. Now, the ex post facto issue is actually currently pending before the California Supreme Court in a number of other cases. I would expect to see a grant and hold in this particular case's future. Now we have two contracts cases. First, in Nungaray versus Lytton Loan Servicing, the 2nd District held that a loan workout plan, which, if specified conditions were met, would be executed by the lender and would then become a loan modification agreement, was not itself an enforceable contract. After examining the plan documents, the court concluded that, as a matter of law, the plan did not obligate the lender to provide the borrowers with a permanent loan modification. Language in the plan made it clear that it did not constitute a contract or loan modification until and unless a final loan modification agreement was executed, which never happened, since the borrowers were unable to satisfy the requirements of the plan. For the same reasons, the court rejected an equitable estoppel argument, noting that the lender had done nothing to lead the borrowers to believe that a permanent loan modification was forthcoming. And finally, another contracts case in Linear Technology Corporation versus Tokyo Electron Limited. The plaintiff, which purchased semiconductor processing equipment from defendant, sued for breach of the statutory warranty under UCC 2312. Now, Section 2312 provides that, unless otherwise agreed, a seller who is a merchant regularly dealing in goods of the kind warrants that the goods shall be delivered free of the rightful claim of any third person by way of infringement or the like. Plaintiff had previously been sued multiple times by Texas Instruments for patent infringement, and the suit against Tokyo Electron for breach of warranty arose out of those actions. However, the jury found against the plaintiff, and the plaintiff then filed a motion for judgment notwithstanding the verdict, which was denied. Plaintiff appealed. Now, trying to reverse a jury verdict on appeal and denial of a J&OV is, of course, extraordinarily difficult, given the standard of review. And the result in this case, an affirmance by the 6th District, was no surprise. The 6th District looked at the record and found evidence introduced by the defendant from which a jury might well have concluded that the defendant's products were simply not the ones responsible for triggering Texas Instruments' lawsuits against the plaintiff. The 6th District then also affirmed an award of attorney's fees to the defendant, relying upon the fact that the plaintiff had pled and sought attorney's fees for its contract claim, and that Civil Code Section 1717's reciprocity principle applied to make attorney's fees available then to the defendant. And that's it for today's Kelso Report. Have a great day in the law and a safe and happy Thanksgiving vacation. We'll see you next week.